(2016-177), State of Arkansas versus Donald Dunklin. This matter was on a scheduling order that had it for trial during the week of January 30th. There was a non-appearance on one date, at least, back in October. The matter was continued over till today's date, and there's a motion pending filed by Mr. Cooper for a continuance in this matter. Mr. Bunch, where do we stand?
Case appears to be in a trial-ready status. Discovery's complete as far as I can tell.
I think I'm going to go to a regular lawyer.
What?
I'm talking to the judge. I don't need y'all no more.
Oh, okay. Your Honor, Mr. Dunklin would like to speak directly to the court if you could, please.
Yes, sir.
Your Honor, I think in my best interest, I think I need another lawyer. I think that I need to go outside the public defender office and get me another lawyer.
Are you proposing to hire counsel?
Yes, sir. I ain't got no choice. I have not talked to this lawyer not one time since this whole case. I don't even know the man's name. I don't know nothing. 5 months, never talked to him. He talked to me on the phone the day before court. 5-10 minutes, that's it. Oh, sorry.
Well, I know that you're an over-the-road truck driver. Is
Yes,
that
sir.
correct? All right. Well, the court, this matter was, you were in court on the 23rd of June, and that's when we set this matter for trial and appointed the public defender's office.
Yes, sir.
Okay. On that date, you didn't speak to Mr. Cooper?
No, sir.
Or anyone from the...
I mean, I talked to them on, like I said, by telephone the day before I got ready to come to my court appearance and stuff like that. But as far as sitting down talking to him, and last time I talked to him, he told me that something came from them. And that's all I know.
I mean, the way this system works is that you're getting a free lawyer appointed to you. It's your obligation to stay in touch with him. He's not, he doesn't have time. He's probably got, at any one time, the lawyers in the public defender's office have several hundred clients.
I know.
And they're, we're pushing them to move these cases. So it's really your obligation to stay in touch with him, call, make an appointment, and get in to see him. Now, if you're saying at this point you don't want to use the service of the public defender's office and want to hire counsel, you're free to do that. That's your right. And I will continue the case if that's what needs to be done to give you a chance to hire counsel. But I'm going to reset it on a relatively prompt basis because this case is getting to be one of the older cases on the docket.
Right.
So is that your request, is that you want to separate from the public defender's office and hire counsel?
Well, Your Honor, I really don't have no choice because, like you just said, it's getting old, and me coming back and forth up here, that's a long trip.
Okay.
That's 17 hours.
It may be a long trip, sir, but whatever the trouble is, it occurred here.
Yes, sir.
The public defender's office is here. They're manned you know, on a steady basis. It isn't hard to set up a schedule and appointment with them. That's not a hard thing to do. I don't know what the problems have been. Mr. Cooper isn't here today to address this. He's out sick. I'll be glad to schedule an appointment where you and he can be in the same courtroom as the court, and we can discuss what the problems are.
Okay, that's fair enough. That's fair.
Well, then let's set this down. I'm going to continue it on this date. I'm continuing it from today's date until March 23rd. I want you to try to put that on your schedule. And in the meantime, that's the next date I'm holding court in this courtroom, and we can discuss this matter. In the meantime, get the information, if you don't already have it, of how to contact him. Call him and see if you can't make an appointment and discuss it with him directly.
Yes, sir.
Mr. Cooper's a very easy man to work with. He's not a difficult person. We have had difficult public defenders in the past, but at the present time, Mr. Cooper who's serving my court with the public defender's office. He's a very easy person to work with. If you call, make an appointment, and get in to see him, I'm sure this matter can be straightened out. But if not, so I'm continuing it from today's date until March 23rd at defense request as an excluded period. And we'll if it needs thrashing out, we'll thrash it out on March 23rd.
Yes, sir.
All right. All right. Now, so that's your next appearance date. In the meantime, I'm directing you to get in touch with their office and try to set up an appointment and see if you and Mr. Cooper can't get together and get your issues straightened out. If not, we'll discuss what needs to be done on March 23rd.
Yes, sir.
You may be excused. I understand you have a load to get.
Yes, sir. I got to go.
All right.
Thank you, sir.
You may be excused.
Thank you.
I'm calling 2017-98 State of Arkansas versus Jason Chorba. Mr. Chorba, the court is, this matter is for arraignment on a charge of breaking or entering a Class C felony and theft of property, a Class D felony. Have you made any efforts to get a public defender or to get an attorney representing you?
He has, Your Honor. I have the application here. It appears he will qualify. I'll bring that to the court when I come back.
All right.
At this point in time, we will waive reading of the information, enter a plea of not guilty. We'd also like to ask that Mr. Chorba be transported over this afternoon for probable plea in this matter.
All right. I'll put him down to be brought over this afternoon after he noted the appointment of the public defender's office and entering a plea of not guilty. All right.
Thank you, Your Honor.
Go ahead. You may be excused. 2017-95 State of Arkansas versus Rabona Jones.
Judge, this is Ms. Rabona Jones. She's
Okay.
filled out an application. It seems that she will qualify. We'll go ahead and enter our appearance. Enter
All right.
not on her behalf.
Public defender will be appointed. Plea of not guilty is noted. She's co-defendant with Ms. Deathridge. This is for reappearance again in front of Judge Putman on March 2nd.
Judge, Ms. Jones would like to request a bond reduction today on these charges.
What's being shown is the jail of the bond over there. This appears the bond's been set at $2,500.
5,000 is what we show, Your Honor.
That's on the information, but the information has $2,500.
Judge, we would ask that the jail's record reflect that amount. That's not objectionable. She's been in touch with the bondsman.
All right. Bond to be $2,500. 2017-99, 296, State of Arkansas versus Scott Freud. The 2017-99 case, the case is for arraignment today.
Judge, I believe we've been appointed already in this matter. We waive reading of the information and our plea of not guilty on Mr. Freud's behalf.
So the plea of not guilty is noted. In the other case involving Mr. Freud, 2016-296, Mr. Freud, on February 16th, a petition to revoke a suspended sentence was filed against you. The allegations in the petition to revoke are that Mr. Freud tested positive for amphetamines while on probation, committed the offense of possession of drug paraphernalia, a new charge. I guess that's the new charge we just arraigned him on. Had a second positive test. Or no, was found in possession of drug paraphernalia, second offense, cooperation, failure to cooperate, and failure to follow the directive of his probation officer, and he was alleged to be in association with a convicted felon. All of violations of terms and conditions of probation. Have you been appointed to represent him, Mr. Bailey?
I believe we have, Judge. At this point, we'll enter a plea of not true to those allegations. He would like to request a bond on both charges, the revocation and the new charge.
The arrest on the revocation occurred on February 17th. The court's going to set the revocation down for March 23rd. That's for hearing on March 23rd. Now, the other case is on the Division 3 docket. The court has to hear the revocation because I'm the one who took his plea. I don't know whether there's a basis to transfer this or not, or whether just let it go on Judge Putman's docket. Is there a motion by either side?
Your Honor, you can leave the new case on Judge Putnam's docket. We'll be glad to take care of the revocation case with you at the very next hearing.
I'll set him down on the new case for reappearance on March 2nd in front of Judge Putnam. On the issue of bond, I'm going to set bond at...
Your Honor, as the court is saying that, I would like to bring the court's attention. He'd been on probation for less than 3 weeks before we had the new charges, Your Honor.
I understand.
The court gave him some deference in his previous case that he abused also, Your Honor.
Judge, he does want the court to know that he is employed. He does have employment. He has only been on probation a very short amount of time. We understand that.
Well, Mr. Freud, the court's observation is that it really isn't a difficult thing to stay in touch with your probation officer and communicate with your probation officer, considering you're on probation kind of as an alternative to being sent to the penitentiary. So the court doesn't have a lot of sympathy with those kind of allegations involved, and I recognize there are allegations at this point. You haven't been found to have violated anything, but I don't see in the allegations that are contained in the petition to revoke a lot of effort on your part to comply with probation. So what the court's going to do is I'll set bond, but I'm going to set it at $10,000, cash or pro, covering both cases. It'll also be conditioned upon the defendant if he bonds out, he's to report to probation within 24 hours and to get back in full compliance with all the requirements of probation immediately.
Thank you, Your Honor.
State of Arkansas versus Tyler Wheeler. Mr. Wheeler, you're down for arraignment on charges of possession of a controlled substance, methamphetamine, Class D felony, possession of drug paraphernalia with the purpose of ingesting methamphetamine, Class D felony. Have you made arrangements to be represented by counsel?
He has, Your Honor. We have an application here. He is going to qualify, therefore we'll enter our appearance, enter plea not guilty on his behalf.
Plea of not guilty is noted. This case is on the Division 4 docket of this court. I'm going to set it by scheduling order. Let's first of all make a determination on. Court's going to, apparently the arrest date was February 20th, and the court's going to set it down by scheduling order for trial the week of September 18th of 2017. Set a pre-trial date of August 17th, and then I'm setting it for a reappearance on June 22nd. The reappearance date is just to check the status of the case.
Judge, I'll inform Mr. Wheeler that if something can be worked out prior to that date, that he can be brought back, of course.
Yes.
For a plea, that's what can happen.
Mr. Wheeler, the Public Defender's Office is going to represent you. It's your obligation to get in, and if you do bond out, it's your obligation to get in and see them as promptly as possible. Make your appointment and get in to see them. The Public Defender's Office, stay in touch with them. They can't prepare a case on your behalf until you get in to talk to them about what your case, what the issues are in your case, and that's your obligation to do. Don't wait around expecting the lawyer to have time to come find you wherever you may be. So that's where we are on this case. Is there a request for bond? No, bond was set at $2,500.
There's no issue there. Judge, yes.
Oh, that's right. Roll. All right. Very well. You may be excused. 2017-101, State of Arkansas versus Caleb Waddell. Caleb Waddell is, you're Mr. Waddell? All right. Mr. Waddell, the charges against you are possession of a controlled substance with the purpose to deliver marijuana, Class C felony, possession of drug paraphernalia, Class D felony, simultaneous possession of drugs and firearm, Class Y felony, possession of a defaced firearm, Class D felony, and there's an enhancement provision on this for proximity to certain facilities, and the possession of drug paraphernalia, Class A misdemeanor. All of those are the charges in your case. Have you made application to the Public Defender's Office?
He has, Your Honor, and he will be approved. We'd like to enter a plea of not guilty and be heard on bond.
All right. Plea of not guilty is noted. This matter is set for a reappearance in front of Judge Putman on March 2nd to get on his scheduling order. Judge Duffy reviewed this matter and set bond at $30,000.
Judge,
Cash or professional?
Judge, Mr. Waddell lives here in Mountain Home on Rossi Road. He's lived here his entire life. He does have some misdemeanors in his criminal history, but he's never been charged with a felony. We would ask the court to consider those factors, and we would ask for a $1,500 cash or surety bond to assure his reappearance before this court.
Does he have employment?
Judge, he has worked at Ranger Boats most recently. He has an application in at Vastcat and assumes that he can get that job once he's released.
What says the state?
You know, the charges against Mr. Waddell are significant, and we do not believe that $1,500 is an appropriate bond based on what he is charged with. The state is not objectionable to the bond being reduced to a reasonable level. We do not think $1,500 is appropriate when a Class Y felony exists in this case, Your Honor.
Court will reduce the bond. I'm going to set it at $10,000, cash or professional. That'll be the bond in this case. You may be excused, sir. Your next appearance is March 2nd in front of Judge Putnam. (2017-93) State of Arkansas versus Christie Lund is for arraignment on charges of theft of property.
Does she fill out an application? It appears she will qualify. We'll enter a plea of not guilty on her behalf, but I'll put her on bond.
Plea of not guilty is notified, noted on the record. So again, this matter is on Judge Putnam's docket. I'm setting you down for reappearance on March 2nd. Bond has been set at $10,000.
Judge, we would like to request a reduction to that today. I've spoken with her this morning. She has first and foremost in her mind, she has a significant medical issue that I've spoken with jail staff about, and they are treating her for it now. But it does cause her some discomfort here at the jail. Beyond that, in speaking with her, I believe there's a lack of a criminal history. This type of case generally, as the court knows, according to sentencing guidelines and criminal histories of the defendants that appear before this court often, is a probation case, probably. And so based on that, we would actually consider a low bond to reassure her appearance here. She does live here in Mountain Home. She has family over in Kentucky and Tennessee, and that's where she was when she was arrested. But based on her lack of criminal history and her time in the community here, we would ask that the court consider we'd ask the court to consider an OR bond. I know that's not highly likely, but I believe she is a candidate for one, Judge, based on what I've said.
What connections to the community does she have?
Because she does have family that lives here. What family lives here?
I have an aunt and uncle, and I have some cousins, and my daughter.
She has a 9-year-old daughter, Your Honor. She's lived in Baxter County for the past 2 years.
Your Honor, we had to go to Tennessee to get this thing.
I understand.
Doesn't mean that she knew there was a warrant, Judge.
The reason the court had noted that the bond and it had essentially approved the bond as it was stated was the fact that she was out of state and after the relatively short time after the offense, the property was taken, and the court is going to leave the bond at $10,000. Of course, that the request for a bond reduction can be renewed when the matter comes up in front of Judge Putnam a week from today. So,
Thank you, Your Honor.
bond to be left at $10,000 at this time. If she makes bond, the bond will be conditioned upon not leaving the state of Arkansas. All right, you may be excused.